All right, the 864. I put up this picture of a maze because essentially that's what it is. We have a certain way of doing our 864s, which is, oh, it looks like we have a question.
Yeah, Jess, we have a follow-up question. Vanessa would like to know, how would the government find out if the sponsor is not meeting their obligation in the first place?
So essentially, it's all tied in together. If we have a Medicaid patient or if we had cash assistance, usually that was one way to trigger it. The one way we had it come up was a spouse actually informed the government and said, look, this person's on cash assistance, he's on Medicaid, you guys didn't catch it, you should go after the person. It actually never happened, but that's the one way we saw it. The other possibility is, say, for example, you had a client that was on a green card, went outside of the country, stayed over more than 6 months out of the country, and then was essentially applying for admission on the way back. That's another possibility. And so for some of the practitioners, you should ask that, even though for naturalization it's not part of the equation if you're applying for citizenship, but that is certainly something you should ask the client, like, hey, as a green card holder, for example, did you receive these public benefits? And go back to that list and see if they did. But that's another method of the government finding out. And so we did have a judge in our last session say, we have been adjudicating these situations where an 864 has been signed, but that person went on a public benefit, and so they're enforcing these costs. All right, let's go to the next slide. So before we go into detail about the 864 form, let's talk about just some general guidelines. The affidavit of support is basically helping to prove that the person that's applying for the green card will not become a public charge. And the next point, which is the petitioner who filed for the applicant must be its sponsor. So a lot of times we represent younger applicants. So it'll be a U.S. citizen spouse applying for his new wife, and the wife has not, they're both students and they've not paid their taxes in the last 5 years. So no matter their income, the husband still has to apply, or the wife has to apply, even though they didn't pay income for the last 3 years. If they can't meet the requirements, the client will be filing a joint sponsor. They'll be looking to get a joint sponsor. And that person is used in place of the petitioner's income. So back to that example of the young couple, the U.S. citizen husband that was in school, met his wife in school, paid no taxes in the last 3 years, they would need to get a joint sponsor, and we do those joint sponsor documents all the time. We'll also be addressing later on in the conversation the ethical issues of doing that. And so, but back to the 864, know that only 2 joint sponsors can be used on a single petition. Most of our work, if the applicant doesn't have enough income, there will be an uncle or a friend that's a U.S. citizen or green card holder. They'll give us their taxes, and then we'll include that in the green card application. Remember, same thing applies in consular processing. So if the spouse doesn't have enough income, we can find a joint sponsor and upload those taxes to the National Visa Center site, and that person is used as well. Sometimes in that scenario of the college husband and wife, they may not know anybody, but they may have some assets. And so if we're using assets in that 864 application, those assets must be convertible to cash within 1 year. And the net worth of the assets has to be 5 times the difference between the actual income when we're submitting the 864. So take a look at the net worth of the assets and see if it's 5 times the difference between the sponsor's actual income.
Jess, is there a fee associated with the 864 filing?
Not currently, there is not. Recently, there's been talk about expanding the 864 application and including credit reports, bank account statements. And if you think about that, that's a really difficult thing to ask if you're in need of a joint sponsor, to ask somebody, hey, please sign your life away, but at the same time, can you please give us your credit report, list of assets, and everything else? I mean, that's really difficult to do. And so a lot of times, most people that are applying, they want to do it in-house, they want to do it themselves. And so if you can't find a joint sponsor, we'll ask for assets, and we'll discuss that in the application later down the line. This I-864P is a form I look at pretty much on a weekly basis. I don't have these numbers memorized. And so when a client calls us and says, hey, look, I'm applying for my parents in another country. It's me, my wife, and a kid. We'll take a look at this chart. And if you are an armed forces member, you look at the first column. If you live in any of the other 48 states, you have to be within the 125% of the poverty guidelines in the second column. So always take a look at the person that's signing the 864 on the left side, and then see how many people they're sponsoring, and then add those numbers up and take a look at how much minimal income they have to make for this to go through. All right, so if you ever want to pull up the form, it's free. It's always on the uscis.gov website. And without fail, I tell my staff, always pull it off the government website. Make sure it's not an expired form. If you take a look at the form, and for the folks at home, if you want, you could pull up the 864 form from the, and we'll give you a few seconds to do that. So when we fill out the 864, the first thing I always do when I'm looking over a staff member's form is to look in the right-hand corner to see if it's not an expired form. And it's happened before by accident where people will try to do a save as and just use an older form and just change the names and information, but the form is expired. So always take a look at that. Typically, our office does 864s, and right behind it, an 864A if we need to have a member sign as well, like a spouse. The 864EZ is a shorter version, but essentially asks the same questions as the 864. Always, when you fill out this form, we include a copy of the person's U.S. passport or green card or birth certificate to prove that they're a U.S. citizen. So if we look at page 1, we'll just fly through this. This would start off with the sponsor's information. 1E if we're including a joint sponsor, make sure it's a completely separate form. It's not put all on one form. Include 3 years of taxes. So if we're in 2020, we're including 2020 taxes, 2019, 2018, and 2017. And to make it easy for your client, we usually have them go on the IRS website and ask for the IRS transcript. One issue we should discuss is you have to remember that the 864 back in the day used to take care of the public charge rule by itself, and now it's just one factor. So if you think back to the totality of the circumstance test, in addition to the affidavit of support, the government's taking a look at that person's age, health, family status, financial resources, and education. So if you have somebody that has high income, great. Then more likely than not, we're an issue. But if it's low, you got to make sure you have all those other factors addressed. Page 2, it's pretty straightforward. The first question is usually where we have the issues. We usually will check mark yes and then move along because most of our cases are spouse cases. If it's anybody else, like a child, include that in the family member section. And one nice thing is the new form will automatically fill number 29, and that will assist you later on in the application. Everything else is pretty self-explanatory. Put the sponsor's mailing address, where they were born, their country of birth, their social security, which is required, so don't forget that. Whether they're a U.S. citizen or a green card holder. And then we move on to the next slide, which usually causes the most confusion. So let's think about a situation where a son is applying for their mom and dad. And so you would enter 2 for the mom and dad, for the people that you're sponsoring. And then below that, 1 for yourself, 1 for your wife, and then 1 for your kid, for a total number of 5 with respect to the household size. So we take a look at 5 members in the sponsor's household size. That person needs to make $38,350 adjusted gross income on their federal taxes in order to qualify. If they don't, then we'll need a joint sponsor. One mistake we see quite a bit is in a spouse case. Number 1, they'll put that 1 there, and then number 2, they'll put another 1 counting themselves. And then if you're currently married, they'll put another 1 there, and then eventually that household size turns into 3. But remember, the question says persons that are not sponsored in the affidavit is what you have to do. So take a look at that. Everything else is pretty straightforward. If you look at part 6, that's the other place that causes confusion, is the current annual household income. We'll take that from your current tax. We'll plug that number in there. If that person is a spouse, we're not filing an 864A. And so you would check that box that says that person does not need to complete an 864A because they're the intending immigrant. If in our scenario of the son applying for the parents, that person's wife would also be filing the 864A. And remember, the 864A person that's filling that out has the opportunity to get sued just as equally as the sponsor. So make sure that person knows those obligations as well. We always include 3 years of the taxes, so we always check optional, and you plug in your tax income as your adjusted gross income in those boxes in 24, 20. In that scenario, if we're low with respects to the income, we'll take a look at the son's assets and see if we could include their assets in Part 7, such as checking account, bonds or certificates. A house is something we usually use, and we'll include a recent appraisal, which most people don't have, or we'll just take a look at the county tax records and submit a copy there. So if we're low on income, then we'll include assets. If that son, for example, is less than $38,000, then the son would need a joint sponsor. Things that causes trouble sometimes when we need a joint sponsor is the government pretty much spells out Part 8 that you're signing a contract with the U.S. government that essentially if the intending immigrant goes on a federal benefit, the government will come after you to enforce those costs. And we'll go into when these obligations end in the next slides. But after that, you basically sign and date, and again, include a copy of your proof as a green card holder or a citizen, the 3 years of taxes, and you include it in the package. If you're applying for a green card, if you have somebody out of the country coming, you would upload that to the NVC. When we were talking about that scenario, we had, potentially a son that didn't have enough income, and we had to use assets. I'd like to include this slide that we got from the ILRC book that I recommend everybody get. But this was a nice scenario that basically shows that you can mix and match to get to the 125%. So in this example, we had Caroline, a U.S. citizen that had 4 people in her house and wanted to sponsor her husband, but she only made $20,000 in income. And if you had a household of 5, you need to make $38,350. Caroline in this scenario owns her house, which has an appraised value of $60K. And the question is, can we use ownership to make up for the remaining income? And the answer is yes. And a lot of times in our practice, we will mix and match. We'll get assets, we'll ask for stocks and bonds just to put us over that threshold. And before the public charge rules, we would say, we're over the threshold, we got our foot in the door, it won't be an issue at the green card interview. I've never had a situation where an officer at the USCIS building ask our client, hey, you know what, your taxes just barely got you through above the threshold. We think this person might be a public charge. It's never happened. Now we're all on the same footing. There's no immigration attorneys out there that could say, hey, you know what, this is what happened in our adjustment case because of COVID. A lot of these green card applications haven't seen the time of day yet, especially in Sacramento. I don't know how it is in other jurisdictions, but currently from March to November, the majority of our clients that are getting interviews are folks with citizenship applications. So we can't go off on too much experience. So I apologize if I'm a little bit all over the place with what an officer could potentially ask for an interview with respect to this, but the more the merrier. We would suggest to our attorney friends to take as much evidence of finances to the interview. So take a look at this slide just to get this mix and match concept. And when will these obligations end? This is always a fun conversation when you're having with a joint sponsor, but basically if you are a sponsor, your obligation ends when you become a US citizen. You have worked for at least 40 quarters, essentially 10 years. That person has either departed the United States or subject to removal or dies. And I like how they put it at the end that if you die, then great, you're off the hook. Mostly, the scenario is once a person becomes a US citizen, then that obligation ends. And one of the main points that we were discussing earlier was what are the obligations in a husband-wife scenario when a divorce happens? What happens then? And before we get into that, for a few of our attorneys, I wanted to give this scenario of the ethical dilemma in representing a joint sponsor. So we had a scenario where we were representing an older gentleman, maybe 75, and the wife was the intending immigrant. The husband was in bad health. The husband filed bankruptcy in the past. The husband didn't have enough income. And so, it was very obvious that the husband needed a joint sponsor. And so after finally asking for the help of an individual to become the joint sponsor called me and said, hey, what are my obligations? And it was just ridiculously obvious that, I would have a fiduciary duty not only to the joint sponsor, but to my client. And so I couldn't hide anything from this joint sponsor. And essentially what happened was we told our client, look, we can't represent you and the joint sponsor at the same time. It'll be easier if she just hires her own attorney, and we farmed it out to separate counsel. The joint sponsor talked to that separate counsel, felt a lot better, and put us off the hook. So be very mindful of that, guys. When you have a joint sponsor, you have to tell them the full story and let them know, basically, these obligations end on those 5 criteria.